Hello, UCAR. Peter Christensen here, coming to you from the CEO's desk. It's a new month. March is here. We've all been waiting for it. So, new topic comes with the new month. We're going to talk about contract law basics in the month of March. Pretty fun, pretty good stuff. So, let's dive right in. A concept I hear often from real estate agents about contract law is the concept of the four corners of the document. And it must be a phrase used in licensing classes because I hear it a lot. And the basic concept is whatever's in that contract controls. And this becomes really important in a real estate deal, in any deal where you have a contract involved. And the idea is that a court won't look to reinterpret something in the contract if it's clearly stated in the contract. So let's say a deadline. Let's say you put, the deadline is March 7th. But then the parties are talking and they're saying, well, March 7th, but that's a Saturday, so we don't think we'll do it on that day. Let's push it back to March 11th because we got stuff going on. And maybe they're talking, maybe they're even sending texts and emails back and forth. Well, the idea is if that went to court because one party said, well, we talked about changing that date. The idea is the court would not look past the document. They'd say there is nothing ambiguous about that date in the contract. Therefore, we are going to stick with what's in the contract. That's the agreed upon. We don't really care what you guys talked about. We don't really care what was going on the side. We know what the contract says and you agreed to these terms, so we're going to stick with it. So that's one idea, the four corners of the contract. It is a court will not look without an ambiguity. They're not going to look. There's even a rule in the law that says you can't even bring evidence of outside ideas if it's clear in the contract how it was supposed to be. So bringing those emails in, they may not even be allowed to be brought into court to show that, well, your intent was to change it because you didn't. It's in the contract that the date was set. But let's say there's an ambiguity where you're saying dining room set included. And that's in the contract. But there's room for ambiguity because there's a table and chairs. There's also a hutch. There's also a sitting stool. There's also artwork. And what was intended to be included? Well, it's ambiguous. Therefore, a court would then look to try to interpret what they thought the parties meant. There you start to get this parole evidence, this outside evidence brought in to say, look, these emails reference the art, the sitting stool, whatever. And then that's when we get the outside evidence to try to show what was meant in the contract. So the safety is if you have everything well outlined and well spelled out in the contract, then it doesn't matter what's going on outside of the contract. The court should only ever look at the contract if it's clearly defined in there. So powerful stuff in these contracts, but we got to get it right. We got to not have ambiguity. Okay, we're going to dive in much deeper throughout the month on some contract law issues, and I look forward to you tuning in next time. Have a great day.